All right, let's start this. So drone regulatory forecast. Future regulations, let's discuss that. Some over people operations. Really the only people that are considered participating in your operation is the remote pilot in command, the visual observer, manipulator of the controls, and somebody necessary for the safety of the flight. Everyone else is going to be non-participating. So the FAA is currently working on those. And then there's also the beyond visual line of sight operations and night operations. Collectively, the FAA is referring to those as extended type of operations. Additionally, you guys might have heard recently there was the Taylor v. FAA lawsuit, which was just recently resolved up in the DC Circuit Court of Appeals. Well, what happened was the FAA got a little regulate things that they were told by Congress not to regulate. So the FAA is going to have to go back and actually kind of clean up that mess with Part 48. Additionally, you might have some stuff coming down the pike here with remote identification as well as the Lance system, which is going to allow for like kind of wide area rapid authorizations in certain types of airspace near airports. The Administrative Procedures Act, it takes around 3 years from start. They have about 8 to 16 rulemakings they can carry on at any given time. So 3 to 5 brand new regulations coming out, okay, for let's say around 10 maybe getting repealed. So what's the overall effect of everything I just told you right there? Well, if you're going to be doing any type of beyond visual line of sight, night, over people operations, you must do those under Part 107 waivers in the near future because there are going to be there's no chance of regulations coming out in the next couple of years that you can operate under. Thankfully, the waiver process is there. Now, I also want to talk about future case law. So that was future regulations coming out, not going to be happening anytime soon. Future case law. Well, the Taylor case was ruled upon by the DC Circuit Court of Appeals, but that wasn't the only case, okay? Taylor, there was a total of 4 cases Taylor filed, and I helped them out with all 4 of the cases. The 4th one has actually not been ruled upon yet. We'll get a ruling on that most likely sometime this winter. The question that's presented there is, was the creation of Part 101 violating Section 336? And 336, just a quick recap, is 2012, Congress told the FAA, do not create any rule or regulation governing model aircraft. Well, Part 101 is governing model aircraft. It like literally defines it. In that case, and the court will most likely rule that that was a violation. And so the FAA is going to need to go back and actually clean up Part 101 on top of Part 48 as well. So it's just more on the regulatory to-do list that they need to do. Additionally, there's another case up in the District Court of Massachusetts. It has not been ruled upon yet, but it gives us kind of an idea of where some case law might be going, where we might get some rulings of substance at an appeals level, probably about 1.5 years from now or more. And if that's it, it does actually get appealed up. It's the Singer versus City of Newton case. And Singer is a professor actually over at Harvard Medical School. He challenged the local drone ordinance there in the city of Newton, and basically on the grounds that the drone ordinance was preempted under federal law and that his federal right to fly in navigable airspace was actually being infringed upon by the city. So how that gets ruled upon is going to have some effect on other courts. If it does get appealed up to the appellate court, the First Circuit, that would only be binding upon Maine, New Hampshire, Massachusetts, Rhode Island, and only be persuasive for all the other federal circuit courts. It does have the potential of actually scaring some local governments into potentially not creating drone laws if the city of Newton were to lose. Now let's talk briefly about future federal law. The FAA's funding runs out on September the 30th, 2017. That's why you see stuff in the news going on right now talking about the FAA reauthorization. Well, there's a whole bunch of discussion there on privatization of ATC, why the House is for that, while the Senate is against that. People are trying to get that in. If that does happen, at least in the House provision, the language was talking about that the nonprofit organization, which would run air traffic control, which would take it over from the FAA, there was going to be a discussion and a study that's going to need to be done in regards to how much of the costs and burdens should be shifted over onto drone operators. So just kind of keep that in mind. But at this point, that is only merely a provision in the House's side of things, we don't even know if that's going to last, because what happened not that long ago and why we had to basically kick all this down the road here just recently is because the Senate and the House could not come to an agreement, so they had to do a temporary reauthorization to keep the FAA funded. Now, what's interesting to note is that there seems to be kind of a push from some people trying to get some regulations or requirements put into law that their products would potentially, that they would meet those needs, right? So you have remote ID and LANs are the two I'm kind of speaking about. So just be paying attention to that some people might be trying to regulate a need for people to purchase subscription or LANs to have rapid airspace access. And also some have recently mentioned do the protections of Section 336 to allow for drone registration. So what's the effect of all of that? Well, nothing immediate. However, what happens here with the reauthorization? Most likely there's going to be some drone-related stuff snuck in there. It's going to get the ball rolling on more rulemaking for more drone regulations that are going to probably come down the pike 2-3 years down the line from now, as well as some studies. Now, some people that are flying commercially are frustrated that they have to apply for a certificate of authorization to fly in Bravo, Charlie, Delta, or Echo at the surface airspace when you want to fly non-recreationally. And the FAA currently has this paper-based, well, it's not really a paper-based, it's more, there's a human in the loop kind of a set of a system right now. They're automating it more and more, but there's always somebody that's going to have to look at that. And they're trying to automate that with the LANT system, so you would have certain service providers where you'd be able to get on your phone, your computer, and you could type in where you want to fly, and the computers would all talk to each other, and then you could get rapid airspace approvals compared to what we're doing now, which you're looking at a 1 to 2 month wait period for certain types of airspace that you want to fly in. However, that's probably not going to be happening anytime until probably 2018. You might have some small scale rollouts here and there, but you're not going to see anything like nationwide until 2018. What does that mean? Let's put all the pieces together. If you are non-recreational, you don't, and if you need to fly over people at night or beyond visual line of sight, okay, I would highly suggest getting a waiver now because there's no change for the next couple of years with regulations. The waivers last 4 years. You should jump in now if you need to do those type of operations. If you also need to operate near an airport commercially, you might want to think about doing the authorizations now as well, because the LANT system is not going to be coming out probably until 2018. Okay, that's for non-recreational. If you're flying recreationally, the protections in Section 336, keep in mind some people, like AUVSI as well as others, seem to be making some indications publicly that they're trying to undo the protections there to allow for registration. Now, for recreational and non-recreational, for both of you guys, don't expect any federal law or case law to rescue you from state and local drone laws, okay? You're pretty much on your own at this point. You'll need to try and solve those at the state level. I know that they're trying to introduce that at the federal level, but I haven't seen anything that was that really substantive in the bills that have been introduced that actually have some viability. And the case law is going to take so long to develop. And at best with the Singer case, it's only the First Circuit up there in the top part of the New England. So also expect companies to push regulatory changes to create regulatory needs which their product can fulfill. So any questions?
Well, Jonathan, can you tell our audience how to subscribe to, I guess, your listserv kind of thing?
Yeah, exactly. Okay, so on my website, you can go there and you can sign up for my newsletter. I also have a free study guide there. And I'm constantly publishing material because, I mean, there's constantly something coming out. So, I mean, just recently here with the authorizations, the FAA just updated their authorization order. And their waiver process kind of slightly got changed in the back end. They just hired some new people, 11 new people and a new boss, which kind of like changed things up. And they just rolled out as of yesterday a new authorization portal and a new waiver portal. So, I mean, they're just constantly just changing stuff.
And since we have a lot of educators here, I know I've asked you this before, can you talk a little bit about kind of the viability of the memo from Michael Borka regarding the educational use of drones?
Sure. Okay. So I have a whole entire article. I have a whole article on my website just on that very that actual interpretive letter, as well as a larger one for just using drones in an educational setting. So if you want like an incredible, real in-depth analysis of that, I would suggest go to my website. I also put some resources up there for free, resources that are on the internet, and there's a whole entire email newsletter subscription part, and it's free just for the educators. So I would highly suggest jumping on there. It's better to kind of think of this as verse 107 and 336 protections. Whether the court is actually going to continue, I mean, not the court, but the FAA is going to continue recognizing this going forward, it's kind of iffy. It's probably the best way to put that, but what it did say is that if you were an educator at an accredited institution, you could take over without a remote pilot certificate in situations where you were teaching like a drone-related class and there was like an emergency type of need to take over. So if someone is going to crash, you could take over, but it's very, very, very limited to that. You can't just like take it off the ground up and down and show people. It's kind of, think of it more like a situation where some like action movie where you're air traffic control and you gotta like talk the guy down, right? Because the pilot had a heart attack and you're like, okay, look over here, grab this control, right? That was kind of what it was, which one wonders like, how safe is that, right? Because you can't really touch that, right? And unless you think it's an emergency, by then that might be too late. What I've suggested to people is just like go and get your Part 107 certificate, and you could be the remote pilot in command of that flight and have the student be the operator, the person manipulating the controls under your direct supervision. The FAA gives 3 examples of where that is permissible. One, where you have the buddy box system where it's connected, kind of a method where you can hit a button and the drone will just stop in midair. And 3, where you're so close as to be able to quickly take over if need be. One wonders how safe that is, right? Because if their fingers are on the sticks, right, and you kind of rip it out, I'm like, I don't know if that's going to be safe, right? Is the drone crash? You probably caused the crash because you pulled it. The FAA does not control your airspace inside a building that's fully contained. So that's another thing you might want to consider purchasing, maybe like a small set of drones like Cheerson CX-10s or something like that. Fly them indoors and then have the students go and obtain their Part 107 certificates and then go outside and fly. That's one. And then you have your own 107 certificate, kind of watch them, do a kind of a checkout, and then they could obtain their 107 certificate. And I would suggest going that route as opposed to, hey, let's play in this gray area where it's not very clear and it's under very specific circumstances. Just get your 107 and don't really think about it because it's very versatile.
Can you fly under 107 part-time and then also recreational part-time?
Yes. So think of it like hats. Or really, it's going to probably be called the 336 hat here shortly after the second Taylor case. But you have 2 types of hats, and you can flip them on depending upon the intentions of the flight. If you're flying for a non-recreational purpose, and then you're going to be under 107. And so I wouldn't say it's commercial versus non-commercial. I think the better way to put it is recreational versus like non-recreational, because there's sometimes these weird where does the public sector guys fall in, or nonprofit, or just doing R&D for a company, commercial sense, but those would definitely be non-recreational. So I think that's a better way to think about it, but you can do both of those. You're not locked in to one. Now, if you do that, make sure your drone is registered. So it could be commercial. The commercial one, you can fly recreationally, but the recreational registration on Part 48, you could not fly commercially because there wasn't enough information. But I mean, that all got changed here recently. But I mean, I don't think the FAA would probably care if you that just happened. But you keep that in mind when you are flying.
Yeah, so we have some local government folks here too. Can you explain, city public works department, right? Should they just have their employee get Part 107 and do public operation, or COA, or what's the difference there?
Right. Okay. So they have the option as a governmental entity to obtain what's called a public COA, and I have a giant article on my website on this very topic of comparing Section 333 exemption to Part 101 to Part 107 to special representative certificates to public COA to the public blanket COA. You're like, good grief, what's the best thing? Well, I threw them all out there just to kind of compare them all. Public COA has some benefits to it. but for a large majority of the operations, it's not actually that beneficial. It would be better to go just the Part 107 route, but it depends. Some type of governmental operations, why they're governmentally sponsored, if you will. They're not under the definitions in the federal aviation statutes considered a governmental function. A great example would be like some type of news advertising, not advertising, but news type of reporting of what's going on at the county, right? So that's going to not be considered a governmental function. Certain types of public works not going to be considered a public a governmental function per the statutes, which is what the FAA cares about, not what the state came up with or the county came up with. They go by their own little system. They don't care what you call it. So it's a case-by-case situation.
Okay, let's say the fire department wants you to take some drone shots of some operation that they're having.
I mean, a city fire department can obtain a public COA. They can also obtain a Section 333 exemption. They can also obtain a Part 107. The firefighters can have a remote pilot certificate, and you would operate under each of those differently depending upon the needs of the mission. So to give you an example, public COA, firefighting is considered a governmental function. You can obtain a public COA to do firefighting-related activity and fly under that without obtaining a remote pilot certificate or any type of pilot certificates, because the big benefit to being considered a public aircraft operator is that you self-certify. You create your own standards for the pilots that you designate to fly under. So they don't have to obtain a FAA certificate, pilot certificate of some sort. Okay, but if you were to do some type of mission where you would then not considered a public aircraft operator, that's where you'd fall back on Part 107. You're like, well, what would that be? I'm like, oh, well, here's a great example. If you are flying some type of mission that is potentially compensable by FEMA because of disaster response, by definition, in the federal aviation the statutes, you cannot actually fly where you can get any type of compensation back. For that flight, you would not be considered a public aircraft operator. You'd have to do that mission under Part 107. So, and then, depending on what you're trying to do and what type of equipment, you might also need to do that under a Section 333 exemption as opposed to 107, because 107 has certain things and doesn't. I mean, generally your answer is probably you can do a lot of things under 107, but there are times where a public COA, Section 333, or Section 333 exemption would be also beneficial hats for the fire department to have. They could put them on depending on different missions.
Yeah, if a public entity is operating under 107 and 107 doesn't require any hands-on training, in your professional opinion, how much liability exposure does that create for the government?
You always have liability exposure, and especially if that's probably the best way to put that. If you even if you became a public aircraft operator, okay, and weren't operating under 107, there's still some exposure there because your training program that you created to self-certify your own pilots, there's liability there because was that really properly, did you properly train those individuals to what the FAA would consider to maybe be not careless and reckless standards, right? Some people are like, oh, we're just going to get a public COA. Well, if you didn't train the guys, one can make an interesting argument that your pilots are actually operating carelessly and recklessly. Now, whether they're going to do that, that's a whole other discussion. Now, how much when it gets into like immunity and everything, and an attorney being able to sue, I don't know the full extent of that because I don't deal in that area. So I can't delve further into that, but I can see there being some liability there, at least from an FAA potential issue if they don't really know what they're doing.
So I think we're going to stop there. Thank you very much, Jonathan.